Okay, welcome to this session of the Kansas Court of Appeals. I'm Karen Arnoldberger, Chief Judge of the Kansas Court of Appeals, and I'll be presiding over this hearing. Joining me today is Judge Catherine Gardner and Judge Leslie Isherwood. Please keep in mind that we've read your briefs in this matter. We're well aware of the facts of the case, so since you only have 15 minutes to argue, you don't have to spend a lot of time on the facts. We are aware of those. I do notice that there are several people on the call, so I'd like to know who is actually going to do the arguing in each case, or if you're splitting your time among different attorneys. So first, for the appellant, Mr. Dupass, who do we have appearing?
Your Honor, Richard Gillette will be arguing.
Okay.
My co-counsel, Joe Patton, won't.
I see Mr. Patton here. Okay. And but he will not be arguing. You will be arguing.
Not be arguing.
Okay. And for Kansas Insurance Inc. et al.
Patrick Linden on behalf of Kansas Insurance, Thomas County Insurance, and Tim Bader.
Okay. And Mr. Thompson, are you?
I am counsel for Jim McGinnis, separate counsel, and we have agreed to split our time.
Okay. And so how are you going to split that time?
Equally.
Okay. So 7.5 minutes each.
Correct.
Okay. You're going to hold me to that. Okay. And then Mr. Gillette, did you wish to reserve any time in rebuttal?
3 minutes, Your Honor.
Okay. All right. I think that sets us up ready to go. You may begin, Mr. Gillette.
Thank you, Your Honor. I wanted to start by just addressing some of the inaccuracies that were that I found in Appellee's briefs, and they may or may not be important to the decision, but I think it's important to point them out at this stage. One is that the appellees continue to suggest there was a stipulated judgment in the case of Dupass versus Woofter. There was not a stipulated judgment. It was tried to the court. The issue was damages. Their liability was not contested. The defendants were represented. Mr. Woofter was represented, and the appellees had representatives there, although they didn't participate. So I just wanted to correct that, because the suggestion is that there was some kind of collusion, which is not before this court anyway. The other point was there's reference to somehow there was knowledge of a $500,000 claim that that Mr. Woofter knew that he was underinsured at the time we made the claim, and that there was a complaint filed that listed $500,000. I wanted to correct the record there because Arizona rules of civil procedure prohibit the naming of a specific amount in the complaint. There was a general claim, and there was no specific amount. So the $500,000 is just simply not accurate.
Mr. I had one question real quick,
Sure.
and I was looking through the record to try to find it, although it seems like there were some allegations of it throughout. Is it in the record anywhere at what point in time your client realized he only had $100,000 worth of coverage?
Well, my client is Dupass, but as far as Woofter goes, as far as I know, there's nothing in the record until there was, at some point, I think his counsel probably knew because we weren't accepting the policy limits.
Okay.
But there's
nothing in the record as to when that took place, or because I know there was also some discussion about the whole point here is the statute of limitations should have started to run when he had his insurance review, annual insurance review. Do we know when that was?
Well, we know generally that it was in June of 2012. And that's really the issue that we take with the court on that, because we think the Keith versus Scheif and Stockham case is controlling, as is Price, as is Nungesser, and Glenn versus Fleming. We believe that all those cases give a clear direction on how this case is to be decided, and it's not.
Mr. Gillette,
Well, yes.
if I could interrupt you just a second. I think one of my toughest hurdles that I have in this case is your reliance on Keith and Price, and I'm having a lot of difficulty aligning those with your claim when in those cases there was first an underlying invalidity, if you will, that had to be established, and I don't see that here. So how do those cases control the outcome given that disparity?
Well, for two reasons. One is both in Keith and Price, to Judge Berger's comment, well, let me address them separately. Keith was dealing with the failure to obtain a workers' comp coverage. When the claimants made that claim, Keith was on notice. I'm sorry, Scheif and Stockholm was on notice that there was no coverage. They can't claim that they somehow thought there was workers' comp. It wasn't until that judicial determination, though, that triggered the statute of limitations. Similarly, in Price versus Holmes, Lillian Price certainly knew that there was a will contest when there was no distribution, when the probate court didn't take it up, or whatever occurred. She had to have been on notice, yet the courts were very clear that the statute of limitations doesn't begin to run until that judicial determination. And it's similar in this case. We have, well, the damages is central to this. And the reason they are is because they arise out of the contract. You can, in the contract, the restatement indicates that you can't have a contract claim without damages. This case is a tort duty standard of care that arose out of a contract. The tort damages were not established, and therefore the contract damages weren't established. Does that answer your question?
Well, I still think in my reading of Keith and Price, if I could, I don't know, maybe narrow it down to its most fundamental level, is those cases required a two-step process. Like in the workers' comp case, let's first determine whether there even was insurance, and then we'll determine who's responsible for that failure. And then in Price, it was let's first determine if there is a will or if it's valid, and then we'll determine who's at fault. Where I don't see that here. We know that there was insurance here, so that first step does not align with your case, in my opinion. And then moving on to the damages, I guess my next question would be, how does that amount of damages, or that gray area with respect to damages, prohibit your client from going forward to resolve the statute of limitations issue? I don't see where that amount or lack of an amount acts as an impediment for pursuing a claim.
Well, let me, I think you're referring to Mr. Woofter going forward. For policy reasons, if Mr. Woofter goes forward, forget about Nungesser and the prohibition on interpleading your carrier. If he goes forward with the claim, and I don't know what he's suing for, I don't know what his remedy is. If he's suing for reformation, remember that he's suing an agent, not the insurer. The insurer is not going to reform the contract and find coverage and extend coverage. If he sues for specific performance, I don't know what that would look like. Mutual mistake, I don't understand how this is anything other than a unilateral mistake that was unknown. So Mr. Woofter would be prevented from ever protecting himself against the eventuality that there would be an excess verdict, which there was in this case. That excess verdict had not come to fruition yet, so they didn't know the extent of that liability. It's the same analysis that applies in the bad faith cases. In the bad faith cases, you have an implied duty arising out of contract. The courts look at it and as a contract because it arises out of contract, and they apply the statute of limitations, but they don't apply them until there's a final determination on the merits of what that liability is. It's really the finding of actual liability for the judgment. And that's one reason why I pointed out earlier that this was not a stipulated judgment. This was something that was tried to the court, and we had the court entered an award herself.
Let me ask you about those bad faith cases. They do seem to be different. Isn't it true that in such a case, it's actually?
I'm sorry, Your Honor.
You're cutting in and out, Judge.
Oh, I'm sorry.
I don't know. It's like an echo.
I can't hear that, so I will refrain from asking my question. Just go ahead.
I'm sorry.
Yeah, she is withdrawing her question because she understands you're not able to, that she's having some kind of technical difficulty.
Okay.
But this is not an insurance bad faith claim. I mean, you're not claiming that they denied coverage, and this isn't a typical they denied coverage in bad faith. This case is about whether they promised coverage that your now client, who's assigned the rights to you, is alleging that he thought he had more coverage than he did, and that they were deceptive in not providing that kind of coverage. It's not a bad faith claim that they in bad faith didn't offer up $1 million limit at the beginning of the case. I mean,
no, the duties are different. The
right.
Cases parallel each other because you're right. The duty to procure cases are really against the agencies. The bad faith cases are against the insurance companies. The insurance companies have the duty of good faith and fair dealing, duty to settle, duty of equal consideration, and so forth. Whereas the agents have the duty to procure. Those duties, I guess my point is, those duties arise out of contract. They're tort duties. There's not, it's not anywhere written down in the contract. So it's been developed.
What's not written in the contract? The amount of insurance?
The implied duties to procure, or the implied duties of good faith and fair dealing, or the implied duties to settle, so forth. Those duties aren't written down. They're implied. They're tort duties. They're duties of reasonable care. And that's why those cases parallel each other.
And I just have one more factual question. And just tell me if this is in the record or not. I'm assuming this was a personal vehicle he was in. Is that correct? Not a business.
Well, there's some question on that.
Oh.
It was a personal vehicle.
And I'm assuming that the coverage, the $1 million, or at least the allegation is the $1 million coverage he had was more of a commercial policy on his, because he had significant assets, it looks like.
Yes.
Okay.
He had another vehicle. This isn't in the record, I don't believe, but he had another vehicle that was covered under the umbrella policy. Okay. I believe the umbrella policy covered his home. Right. These are all factual issues, but I believe that to be the case, covered his home as well as his farming equipment. There's some question whether or not the deck page states this was a work vehicle. That's why I asked if it, okay. I hedged on whether or not it was a personal vehicle. It was, though, I think, for purposes of this case.
I'll give you a couple more minutes since we've
Oh.
asked a lot of questions. Anything else you want to just sum up, and you'll still have your rebuttal time.
Um, well, again, just addressing the court's ruling, the court suggests that the differences between an insurer and an agent are different. We submit that they are not. They are to be handled the same way in each case. There are implied duties that arise out of contract that require a reasonableness standard. That can't be determined until there's actually an award that shows the insured or the agent didn't place sufficient coverage. And that would be our main point.
Okay, thank you. Mr. Linden, you may proceed.
All right. Very good, Your Honor. Patrick Linden on behalf of Appalese Kansas Insurance, Inc., Thomas County Insurance Agency, Inc., and Tim Mader. May it please the court. The unusual circumstance of this case, and I think that drives part of the outcome here, is the fact that we are dealing with a situation where appellant is not originally the insured party in the case. We're dealing with an assignment from that insured to Mr. Gallette's client. And that, I think, it does limit what claims he can bring. As the appellant acknowledged in the proceedings below, the tort claims were not assignable. So the only claims that Mr. Dupass can bring here or attempt to step into the shoes of the insured are the breach of contract claims. And so I think that creates some issues with how we interpret these principles, because we're looking at cases that largely deal with, whether the underlying claim is a tort claim or a contract claim, or could be brought as both. Here it could only, in this instance, be brought as the contract claim. And as such, I think the disposition of this appeal turns upon two issues. The first issue is, when did the breach of the oral contract claim accrue under the applicable statute, which is 60-512? And two, once that claim accrued, was it told for any reason? And I would submit to your honors that under both of those tests, the appellees should prevail in this case. Turning first to the issue of accrual of the oral breach of contract claim. I think it is black letter law that a breach of contract claim accrues upon breach, regardless of whether or not the party who would later try to seek remedies was aware of that breach. More importantly, here, Mr. Dupass is trying to import tort standards of accrual into a breach of contract claim. I would argue first that that would be contrary to the statutory language of these two statutes. If you look at the 2-year statute of limitations for tort claims, there are subsections talking about how accrual is dependent upon ascertainability of damages or becoming aware of damages. That language is not present in the 3-year statute of limitations on breach of oral contract claims. Thus, in order to find for Mr. Dupass on this first issue, we would have to fundamentally change the law of when contract claims accrue for purposes of the statute of limitations. And we would submit that that accrual date here was the date in which the policy of insurance was provided by the appellees to Mr. and Mrs. Woofter. When they first got the policy, had the opportunity to see that the policy did not conform to what they had requested. There was a question earlier as to when the Woofters may have become available at some later point that the policy limit was not as high as they thought it was. I would agree there's nowhere in our current record that explains a specific date, though there is some references in the record to it being disclosed during discovery in the underlying case. So at some point, clearly there was a communication made on behalf of the Woofters counsel as to what that limit was. And that to me would be at the very latest the date at which that limit would have become clear to the woofters. But again, I don't think that's the date that triggers the accrual of the claim. I think it is the delivery of the policy, and that is the point at which, if there is a breach, that is when the breach occurred and when the claim accrued. So let us move then to the second issue, and that is tolling. And there has been a lot of discussion so far this morning on how we deal with Keith and how we deal with Price in the present context. And I think the way to distinguish and to understand how those cases relate to the case at bar is both in Keith and in Price, you were dealing with a situation where an essential aspect of the claim as to the liability facts was to be determined in some prior litigation. For example, in the Price case, it was whether or not the will had been drafted properly. In the Keith case, it was whether the employer had workers' compensation coverage. Those are not damages. They didn't determine the damages in the case. They determined a key liability fact in those two cases. And at least the way I understand the record, particularly in the Keith case, is that action, the timing of that action was also important in that it was pending at the time some of these issues started to come up. But certainly in the Keith case, the issue of whether or not workers' comp coverage exists is fundamental to the underlying workers' comp case, just as it's fundamental to the later claim against the insurance agent in that case, whether there was a policy of insurance issued to cover the workers' compensation claim. So let's apply those principles to the case at bar. Is there anything that was required to happen first before the assignor here, the Woofters, could have brought a breach of contract claim against my clients? The answer to that is no. Once the delivery of the policy was made, if it was non-conforming, the breach happened at that point. The Woofters could, had they wished, had brought a breach of contract claim against my clients if there was indeed a breach, in order to say, hey, I didn't get what I asked for. I didn't get what I bargained for. Now, admittedly, the accident had not occurred yet. Those damages had not accrued yet, but there had already been a breach of the contract. And at that point, the cause of action had accrued and the statute of limitations began to run. And there was no circumstance after that that necessitates the tolling of the running of that 3-year statute.
We've got about a minute.
All right. There are legions of cases out there that talk about tolling. I know Judge Arnold Berger had a trespass case that involved a tolling issue. That, again, was also a tort case. I don't think it's applicable here. But ultimately, what plaintiff is asking for here is to, I won't say a wholesale rewrite of the statute of limitations law when it comes to breach of contract claims, but it would do a significant modification to Kansas law. If damages are an issue, the uncertainty about damages is sufficient to toll the statute, then I think that would apply to almost any breach of contract claim, because there are many claims of breach of contract where the damages are indefinite and may also depend upon the duties of a third party. What comes to mind is a sales contract where you're an intermediate distributor. You may be sued by your downstream buyer, but you may also have an upstream claim, a claim against your upstream buyer. Does the downstream claim need to wait until the upstream claim is resolved just to figure out what the damages are? I think not. So where the damages, even if the damages are uncertain, the statute of limitations accrues at a clear point when the contract is breached, not when the damages are ascertainable. Similarly, there are no circumstances here that justify tolling of the statute. Therefore, we would ask the court to affirm the judgment and the journal entry entered by the district court in all respects. Thank you.
Mr. Thompson?
Thank you. Good morning, and may it please the court. My name is Todd Thompson, and I represent defendant Jim McGinnis. I want to talk for a moment about the weather, but not what's going on outside. Weather as in WHETHER. In a bad faith case, it must first be determined whether there is excess liability. So that claim can't ripen, if you will, until that's been determined. In the situation of a bad will, it must first be determined whether the will is valid or not. So an action cannot go forward until that determination is made. And that's the distinction between all of the bad faith cases and between Price and Keith and this particular case, because boiled down, the claim here is that the umbrella policy should have covered the car he was driving on the day of the accident. That's a yes or no. And the allegation is no, it did not cover that particular vehicle. We don't need to determine anything else after that. Now, there's some language about tolling and accrual in the case law that probably makes this more complicated than it should be. The reality is you're determining when a claim is fully matured and can be pursued, or when it still needs another ingredient. And for example, in bad faith cases, you have that needed additional ingredient of determining whether there's going to be an amount in excess of the policy limits. In the will situation, you have the question of whether the will was valid. You knew there was a will, but it hasn't yet been determined whether it was valid. In this case, there's no dispute that their umbrella did not cover this policy. And the allegations are that the Woofter reviewed his policy every single year. That's binding upon Mr. Dupass. So Mr. Woofter reviews his coverages in June of every year, and he does that in 2012. He then has an accident. He reviews his coverages again after the accident in June of 2013. And as the trial court found, that's the latest possible date that you could say that Mr. Woofter didn't know or learned, that he did not have umbrella coverage for this particular accident. And more than 3 years passed after that before this lawsuit was filed. So for that reason, the trial court was correct in saying the statute of limitations had expired. I think one of you talked about it being a two-step process on the case law that plaintiff wants to rely on. And that's true. That's that whether. The whether is the first step. And in this case, you don't have that. So no reasonable insured can have a serious motor vehicle accident and then meet with their agent in June of 2013 and not find out what their coverages are. And so the statute is running at the very, very latest. The statute is running in June of 2013, as the trial court found. And so we would suggest it's clear that more than 3 years passed, and that getting too wound up in the issue of tolling or accrual is unnecessary, because even if you take the very latest possible date, more than 3 years passed, and this claim is barred. Are there any questions? Thank you.
Thank you. All right, you've got your 3 minutes of rebuttal, Mr. Gillette.
Thank you, Your Honor. Addressing the issue of knowledge, and the question isn't really whether there was knowledge. Certainly, Mr. Woofter was aware at some point that he didn't have the umbrella coverage. the issue was the extent of his exposure. And that the cases are clear that that can't be determined until there's a judicial determination, just as there was in Price, and just as there was in Keith. Turning to the tolling issue, the analysis of Nungesser, we assert, is directly on point and is in control and controls this case. And the reason is because Mr. Woofter would never have an opportunity to protect himself if he had brought a case prematurely before there was a judicial determination of damages. If he had brought the case, as the appellees suggest, and as I mentioned earlier, he'd have no ability to reform the contract to have his car placed under the umbrella coverage. The insurer wouldn't allow that. He would have no ability
Well,
to.
he brought the contract claim earlier before the determination was made as to how much liability there was in the collision. Couldn't he have argued specific performance that you promised me $1 million coverage? That was the contract. That's what I agreed we had. Therefore, I have $1 million coverage. That could be determined before.
A specific performance against the agent, the insurer is the one that produces the policy. The insurer is never going to allow that. And that's my point, was an insurance company isn't going to somehow just come in and extend their policy because of an agent's error.
No, I know that. You'd have to sue to get that done. But you don't need to have a judgment in excess of $100,000 in order to sue at that point.
If my point would be, he sees that he doesn't have $1 million in coverage. He doesn't know that that's ever going to be a problem. And he goes in and he sues. And the suggestion was, I think in Appellee's brief, that he could sue it for the difference. They may not extend $1 million coverage, but they would refund him presumably his premiums, which doesn't make sense because the premiums would be higher if the Buick was under the $1 million coverage. So there's nothing there to sue for. And it just doesn't, I think Nungesser is controlling in this until there is a judicial determination of exposure. There may be a breach, but it's told. And you're not going to be allowed to bring in an insurer and litigate that either in the third party context or in a direct action under Nungesser. So therefore, we had asked that this court reverse the district court's finding that the statute of limitations be established as the date of the judgment damages in the Arizona court, and that this case be allowed to, or be remanded for further proceedings.
Thank you very much. Any questions from the panel? Okay, that'll conclude this matter. Thank you. We'll get a decision